Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's unpack this. We are diving into a pivotal moment in patent law from 1988. It's a case that kind of set the standard for protecting biological innovation, especially involving living cells. The whole fight, it seems, hinged on defining the difference between what's routine screening versus, well, undue experimentation. This was specifically in the field of monoclonal antibodies, which was really taking off then.
That's exactly right. Our mission today is to dissect Wands. It's a fundamental Federal Circuit decision. In this case, it really defined how much an inventor has to actually disclose to the public. Essentially, it asked, did the inventors give, enough instruction so that someone skilled in the field could replicate their breakthrough without an unreasonable and excessive amount of work? We're going to follow the legal battle that ended up setting the enablement standard for really a whole generation of biotech patents.
Right, so let's get the basics down first for everyone listening. What case are we talking about exactly?
Okay, the case name is Wands, Jack R. Wands, Vincent R. Zarowski Jr., and Hubert J.P. Shoemaker.
Got it. And the case number?
That's Noel 87-1454. It came from the United States Court of Appeals for the Federal Circuit.
Federal Circuit, okay. When was the judgment?
September 30, 1988. And the opinion was written by Judge Edward S. Smith, sitting with Judges Newman and Bissell.
And who was arguing?
Well, Wands and his co-inventors, they were the appellants. Their lawyer was Jorge A. Goldstein, and they were arguing against the Patent and Trademark Office, the PTO. The PTO was represented by John H. Robachek, an associate solicitor.
Okay, so Wands versus the PTO. Now let's jump into the science behind this whole dispute. What was the invention?
So the application itself was filed way back in September 1980. It covered these things called immunoassay methods. They were designed specifically to detect hepatitis B surface antigen, or HBsAg. And the key was they were using monoclonal antibodies. These were pretty cutting-edge tools back then for medical diagnostics.
Right, monoclonal antibodies. The goal there is basically to get an unlimited supply of one very specific pure antibody, isn't it?
Exactly. And the technique they used is called hybridoma technology. You basically fuse an antibody-producing cell, like a lymphocyte, with a cancerous myeloma cell. This creates a sort of hybrid cell line, a hybridoma, that pumps out the specific antibody you want, and crucially, it divides indefinitely, like a little antibody factory.
And the basic methods for making hybridomas, those were already known.
They were generally known, yes. But Wands' invention, their breakthrough, was quite specific. See, most immunoassays at the time used a common type of antibody called IgG. They're smaller. Wands, however, unexpectedly found that these larger IgM antibodies worked much better for detecting HBsAg. They gave superior sensitivity and specificity.
Ah, so the novelty was using IgM and finding ones that worked exceptionally well.
Precisely. And they didn't just claim any IgM, they claimed a class of IgM antibodies that had an extremely high binding affinity for the antigen, specifically a constant of at least 10 URAs. Very sticky antibodies.
So it sounds like Wands was trying to patent a very specific recipe using a known technique. But the key ingredient, this high-affinity IgM antibody, was rare and hard to find.
That sums it up perfectly. And that's where the legal conflict really ignited. The PTO didn't argue about the novelty of using IgM. Their problem was with the scope of the claims. They questioned whether Wands had enabled others to actually make all the antibodies covered by those claims.
Which brings us to the core legal question the court had to tackle.
Yes. The single issue on appeal was, did the written description, the patent application, fully enable someone skilled in the art to make the required monoclonal antibodies without, and this is the key phrase, undue experimentation?
Undue experimentation. And the PTO rejected the claims based on that.
Exactly. They rejected it under 35 U.S.C. Section 112, first paragraph. That's the part of the patent law we call the enablement rule. It basically says you have to describe your invention clearly enough so others can make and use it. The PTO said Wands hadn't done that here.
Okay, so Wands had to fight back. They had to prove making these antibodies didn't require undue effort. What was their defense? How did they argue the work involved was just routine?
Their main argument focused on the state of the art back then. They pointed out that all the starting materials the mice needed for immunization, the hepatitis B antigen, the myeloma cells for fusion, they were all readily available. Anyone could get them. And the actual process steps, immunizing the mice, fusing the cells, screening the resulting hybridomas, these were all well-established lab procedures. This was even supported by previous court cases like Hypertech. So their conclusion was, look, replicating our invention just requires standard, well-known techniques. Yes, there's screening involved, but it's a routine screening, which the law allows.
Okay, makes sense. But then we get to the data, and this is where it gets tricky, right? Because both sides use the exact same experimental result to argue completely opposite points.
Yes, it really became a battle over how to interpret the numbers. Wands focused on their successful runs. They showed that they performed the entire fusion process multiple times. And from the hybridomas they fully tested that showed high binding, they found 9. Of those 9, 4 were successful, meaning they produced the right kind of IgM antibody with the required high affinity. So Wands presented that as a 44% success rate among the candidates they fully characterized. They argued this strongly countered the PTO's claim that the process was unpredictable. They even explained some early failures were just them learning the ropes, not a fundamental problem with the method.
44% success sounds pretty decent, honestly, especially working with biological systems which can be finicky. But the Patent Office took a very different view, didn't they? They looked at the bigger picture.
They did. The PTO looked at the total number of hybridomas Wands initially got that showed high binding affinity. That number was 143. Since Wands only fully tested 9 of those and rigorously proved only 4 worked according to the claims, the PTO calculated the success rate differently. They said, well, it's 4 out of 143. That comes out to just 2.8%. Based on that low number, the PTO concluded that finding the claimed antibodies was so unreliable, so hit or miss, that it would require undue experimentation. Therefore, no patent.
Wow. 44% versus 2.8% from the same experiment data. That really highlights how interpretation can completely change the outcome. It sounds less like a science fight and more like a legal framing contest. How did the Federal Circuit cut through that ambiguity?
Well, ultimately, the Federal Circuit sided with Wands. They reversed the PTO board's decision.
They reversed it. Okay, so how did they justify that? Did they just accept the 44% number, or was it something else?
It was more nuanced than just picking a percentage. The court essentially reframed how to look at the experiment itself. They found the PTO board's interpretation, particularly treating all those 134 stored, partially analyzed cell lines, as definite failures, they called that, strained and unduly harsh. The court emphasized that determining undue experimentation isn't about guaranteeing success on every try. It hinges on a standard of reasonableness.
Okay, reasonableness. But what factors define reasonable in this context?
The court pointed to factors established in earlier cases, like in Reforman. These include things like, how much guidance did the inventor provide? Are there working examples in the patent? What's the general state of the technology? And how predictable or unpredictable is the field overall? In Wands' case, the court found they did provide good guidance. They gave working examples, the successful cell lines, and importantly, all the basic methods were already well known in the field. And here's the crucial part. The court defined the experiment not as the screening of a single hybridoma cell line, but as the entire procedure needed to generate hybridomas in the first place.
Ah, I see. So the experiment was the whole process. Immunize a mouse, get the cells, fuse them, grow them out, and then screen them.
Exactly. And Wands had successfully performed that entire procedure multiple times, resulting in the 4 confirmed successes. The court basically said, yes, you might have to screen a lot of cells at the end, but the overall method works reliably enough to produce the desired result eventually. That screening, they concluded, was just part of the routine process for someone skilled in this area.
So the court decided the effort wasn't undue. What was the legal bedrock for this reasoning?
The main statute was definitely the Enablement Rule 35, U.S.C. Section 112, first paragraph. And the court leaned heavily on precedents like Foreman to define what undue experimentation means, confirming that needing to do some screening, even a significant amount, doesn't automatically kill the patent as long as the overall process is feasible and guided.
Now, wasn't there a judge who didn't fully agree? Judge Newman, she wrote separate, right?
Yes, Judge Pauline Newman. She actually concurred on a minor point that depositing a cell line wasn't strictly necessary here, but she dissented from the main holding about enablement.
She dissented. Why? Didn't she agree the process worked?
Her concern wasn't so much about whether you could make one successful antibody using Wands' method. It was about the breadth of the claims Wands was asking for. She essentially argued that having only 4 proven examples, especially when they came from an initial pool of 143 candidates, just wasn't enough data to justify granting Wands a patent covering all monoclonal high-affinity IgM antibodies for this purpose, as claimed in their broad generic claims.
So her issue was scope. She felt that in a field like genetic engineering, which was still seen as somewhat unpredictable back then, inventors needed more solid proof, more examples, before getting such wide protection over an entire class of molecules.
Precisely. She thought the majority was being a bit too lenient, essentially asking the public, other researchers, to do potentially a lot of that routine screening themselves to figure out the full scope and boundaries of the invention Wands claimed generically.
Yeah.
But the majority opinion carried the day.
And that majority opinion had a pretty big impact, didn't it? What's the legal significance of INRI Wands today, especially for the biotech industry?
Oh, it's monumental. This decision really solidified the standard for patenting inventions involving complex biological materials like hybridomas and other living cells. It established a relatively favorable standard for inventors. It basically said, if you provide a workable method using known techniques and available starting materials, the fact that you need to do some screening, maybe even a lot of screening, to isolate the successful outcomes doesn't necessarily mean your experimentation is undue. This gave biotech inventors more confidence that they could patent broader inventions, which is crucial for protecting innovation in fields where there's inherently a lot of trial and error involved.
So, in short, it protected the recipe, the overall method, even if finding the perfect result from that recipe required sifting through a lot of attempts.
That's a great way to put it. If there's one key takeaway from Wands, it's this legal distinction. The patent system acknowledges that in new, complex scientific fields, success often requires routine screening by skilled people. What it prohibits are claims that demand undue experimentation effort that's unreasonable given the disclosure. And the court decided Wands fell on the routine side of that line.
So at the end of the day, the legal line between a valid patent and a rejected one can really come down to how you define the effort involved. Is it routine work, or is it an unreasonable burden? A huge difference resting on interpretation.
Absolutely, and this raises a fascinating question for today. The Wands decision set the bar for routine screening back in 1988, when scientists might have been manually testing, say, 143 cell lines. But what happens now? We have high-throughput screening, robotics, AI technology can screen maybe 14,000 candidates or more relatively easily and cheaply. Does that massive increase in technological capability effectively raise the bar for enablement? Does routine today mean inventors have to screen vastly more candidates than Wands did just to meet the standard set back then? It's something interesting to consider when looking at modern biotech patents.
That's a really provocative thought, how technology might shift those legal definitions over time. Well, this was a fantastic deep dive into a landmark case. Hopefully everyone listening feels a bit more informed about what it takes to patent these kinds of biological breakthroughs.